It's
Not too early.
it's never too early for veterans.
Don't be.
Well, because
It has several numbers.
your dad's balls. What would be it?
Yeah.
Folks, anything we say they can hear now, so we're live, okay?
That's the toughest part.
Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good morning, everyone. All right, this is S-1-SC-39138, Public Service Company of New Mexico versus New Mexico Public Regulation Commission. Can I have entries of appearance, please?
Chief Justice, Associate Justices, Richard Aldeidris from the Miller Stratford Law Firm, together with co-counsel Stacy Goodman, Associate General Counsel for the Public Service Company of New Mexico, here on behalf of Appellate Public Service Company of New Mexico.
Thank you.
Justices, my name is Carolyn Glick. I will be presenting oral argument on behalf of the New Mexico Public Regulation Commission. Also at the table is Michael Smith, General Counsel for what I'll refer to as the PRC. Jason Marks, a former commissioner and who is representing the Sierra Club and will be also presenting oral argument. Mariel Nanazi, attorney for New Energy Economy. Additionally, I want to recognize Sydney Beatles, who is the attorney for Western Resource Advocates. And she joined in the PRC's answer brief. She was not able to be here because of seating constraints, but she wanted me to tell you that she ceded her time to the other appellees and authorized me to state that Western Resource Advocates' position is that PRC's final order should be upheld because it is a lawful.
Miss, like, this is wildly inappropriate. You're making
I'm
an
sorry.
argument on behalf of a party that is not present, and it's not counted in your time, so
I apologize.
I'm gonna ask you to stop. Mr. Aldeidris, it appears that you have designated 20 minutes for your argument in chief and 10 minutes for rebuttal.
That's correct, Your Honor.
All right. Ms. Glick, 16 minutes,
Correct.
and Mr. Marks, 14.
Yes, Your Honor.
All right, thank you so much. Mr. Aldeidris, you can proceed.
Your Honor.
May it please the court. This appeal arises from PNM's request to abandon a minority interest in the Four Corners Power Plant, which is the company's last coal resource, and for approval of a financing order for its energy transition costs pursuant to the Energy Transition Act, or the ETA. PNM and the Commission were previously before this court in State XREL versus eGolf, when PNM sought to abandon its interest in the San Juan generating station and obtain a financing order. In eGolf, this court had to intervene and order the commission to apply the ETA. And unfortunately, history is repeating itself in this case with the commission's refusal to apply the ETA to PNM's request to abandon its interest in Four Corners and for a financing order. Broadly speaking, the two controversies in this appeal involve: one, whether the commission properly denied PNM's request for abandonment under section 6218(4)(d) of the ETA, and second, whether the commission is precluded under section 6218(12)(h)(2)(c) of the ETA from conducting a prudence review for purposes of disallowing recovery of certain PNM's past investments in rates as of January 1, 2019. Turning to the first issue, the Commission rejected the abandonment based on PNM not conducting, as part of its 2021 Integrated Resource Plan, a hypothetical modeling involving the financial impacts if, in the event PNM were to breach its coal agreement and operating agreement and exit the plant in 2024 and 2028. Under these hypothetical scenarios, PNM and its customers would be financially obligated for the ongoing Four Corners cost, but would no longer have any right to the energy from Four Corners. In addition, on top of that, PNM and its customers would also have to pay for replacement resources. An integrated resource plan, as its name suggests, is a planning tool and does not involve the approval of any specific resources. PNM's 2021 IRP ultimately did not include the hypothetical analyses because it was filed after this case. In lieu of the hypothetical, what PNM did was reflected in its IRP the proposed abandonment of Four Corners in this case. Here, the ruling in eGolf is directly applicable to the Commission's rejection of abandonment based on the stipulation for the hypothetical exits. Please recall that one of the grounds that the Commission cited for denying or not applying the ETA or requiring PNM to file for abandonment in the eGolf case was that PNM had allegedly failed to submit an analysis for exit of San Juan in 2022. The court rejected this grounds and then held that the lawful remedy was for the Commission to order PNM to comply pursuant to Section 6212(1) of the Public Utility Act and not to deny abandonment. If PNM was remiss in not conducting the hypothetical exits, as the Commission claims, then eGolf confirms that the proper remedy was not to deny an abandonment, but to order that PNM comply. The Commission claims that without the modeling of the hypothetical exits, the Commission and other parties were deprived of a baseline against which to compare PNM's abandonment in this case. However, as noted in PNM's Notice of Supplemental Authority submitted on July 26, 2022, in its final order in the IRP case, the Commission adopted the recommendation of the staff that, quote, whether or not PNM met the requirements of this stipulation should not be a reason to delay the acceptance of this IRP. This is consistent with the hearing examiner's determination that this analysis was not meaningful. The hypothetical modeling that the Commission claimed to be essential in this case and as grounds to deny abandonment turned out to be an immaterial issue in the very case, in the IRP case, in which it was to be filed. I turn next to Section 6218(4)(d), which was the second basis for the Commission's denying approval of PNM's abandonment. And that section provides that a utility can defer seeking approval of replacement resources, quote, provided that the application identifies adequate potential new resources sufficient to provide reasonable and proper service to retail customers. Section 6218(4)(d) is one of the provisions of the ETA intended to provide flexibility and to make it easier for utilities to file applications to abandon coal resources and to obtain a financing order. In fact, the ETA as a whole.
Easier, but not without standard. I mean, it seems that in your papers that you argue and focus on potential new resources, but ignore the word identify, and then use an apples to oranges type of comparison for the potential new resources presented to the Commission. I don't know that the ETA intended for the bar to be lowered quite that far.
Well, Your Honor, the ETA, Section 6218(4)(d), provides specific language that I just quoted. And what the Commission did in this case was to require the identification of the actual resources that PNM intended to replace Four Corners with. And I submit.
Mr. Alvijoz, how is PNM's or how is the Public Service Commission supposed to determine whether those resources are adequate if they don't know what they are, if they're just these hypothetical proxies?
the way it does most of what the commission does. The commission relies extensively on modeling of resources, the IRP process.
But modeling related to the project, not modeling related to another project, which is what PNM did here. They took modeling from San Juan and tried to bootstrap that into Four Corners. And isn't the commission within its, kind of boundaries to determine and declare that that's not sufficient?
Well, the commission didn't exactly do that. What the commission said was, we're going to graft on a requirement to section 6218-4D that you must present actual resources.
No, that was specific to this case and what they needed for this case. You're not suggesting that the commission said in every case you have to have actual resources.
Well, I'm suggesting that when it applied in this case, the commission did graft on language that does not appear in the statute at all.
Does the commission have some discretion to decide what information it needs in order to make that determination?
The commission, certainly has some expertise, but I think we need to get back to what the language in section and what happened in this case, the language in section 6218-4D provides. As reflected in the record, early on in this case, the parties moved to dismiss PNM's application based on the claim that it failed to make the showing under section 6218-4D. And the hearing examiner considered these claims and ruled on February 26, 2021, that the information contained in PNM's application made the necessary showing of potential replacement resources to allow PNM's application to move forward, and it did. In the answer briefs in this matter, the hearing examiner's determination on this point was attacked, and the commission asserted, of course, that it could reach a different decision than what was proposed by the hearing examiner. And while it's generally true that the commission is free to reach different conclusions than the hearing examiner, section 6218-4D requires that the adequacy of the showing of the potential resources be determined based on the information in the application. That is, it is a threshold determination that needs to be made. And under the ETA, it was incumbent on the commission to assess the adequacy of PNM's application at the time it was challenged in January of 2021, and not to sit back and let the case be tried. And then when it determined...
What procedural mechanism would the commission have to step in and usurp the process in front of the hearing examiner? I mean, that seems to me to be what you're suggesting.
Not at all, Your Honor. The commission is actually the only body that can determine whether a case should be dismissed or not dismissed. And so the hearing examiner cannot say this case is dismissed. It would make a recommended decision to go up to the commission, but could not dismiss the case. What I'm saying is under the ETA, it was the commission's duty, if it disagreed with its hearing examiner, who said, please proceed, it was the duty of the commission to intervene and say, no, we disagree. But they did not do that.
So in this case, they neither affirmed or reversed the decision on the dismissal of the hearing officer, or the recommendation, excuse me.
Well, they departed from the recommendation of the hearing examiner,
In
both
December.
at the threshold and also on the final order.
So they did it in January when the motion was filed and a recommendation was issued by the hearing officer.
They did nothing
They said
in January.
nothing. They were silent.
Exactly. They did nothing. The ruling was actually in February and the commission did nothing. We never heard from it.
So help me understand Chief Justice's question. Is it your expectation that the commission at that point would have sent down to the hearing officer a standard of the type of evidence that's required? Meaning, hypothetical is not good, we want actuals. Is that your expectation?
It really is that they would make a determination if it's challenged, and it was, at the very beginning of the case, to say whether or not we've met the threshold.
Well, and isn't a denial of a motion to dismiss, isn't that interlocutory in nature and can be revisited at any time?
It was possible that the other parties could have sought interlocutory review. They did
No,
not.
not about an interlocutory review. A denial of a motion to dismiss doesn't mean it cannot be dismissed later. It is interlocutory in nature in our jurisprudence. And so it seems to me your one of your concerns about the commission is that they didn't step in at the beginning and say, no, we think this is insufficient, grant the motion, as opposed to waiting until they decided when they decided. But if denial of a motion to dismiss, which is essentially what happened here,
Right.
can be revisited at any time because it is interlocutory.
You're absolutely right, Your Honor. It can be revisited. I think in this case, the procedural status was such and the requirements of the ETA were such that they should have intervened. Now, if the case had progressed and it determined that, after evidence was presented that, the analysis was flawed, that there weren't RFPs or something like that, certainly the commission was free to reach a different resolution, but that's not what has happened.
Can you tell me what do you rely on to support your claim that the PRC should have intervened at that time?
I'm relying on the ETA itself, which says that the determination is to be based on the information in the application.
And you're talking about section D of.
Section 6218 4D.
So it seems like you're suggesting almost that the commission should just rubber stamp if there's potential new resources identified in the application, as opposed to weighing whether or not the application identifies adequate potential new resources. It almost seems as you're suggesting that it was a very low threshold that almost should have been rubber stamped, as opposed to really making a decision and looking at the evidence as to whether they thought there was adequate potential new resources.
Well, Your Honor, I'd like to turn to the evidence that was presented. And the evidence that was presented with the application was that there were based on recent RFP responses, there were between 6,500 and 10,000 megawatts of available.
But that's based on modeling. So please explain to me, so I can understand it, how a model which is based upon hypotheticals equates to identifying adequate potential new resources. A hypothetical, in my mind, does not necessarily identify. And what the statute requires is for the applicant to identify, not to present a hypothetical.
What, Your Honor, what the statute requires is that the applicant come forward with an array of resources, and the company did identify very specifically the types of resources that it anticipated would be deployed.
It doesn't say identify the types of resources. It says identify the resources.
It identifies potential resources, and I think that's the important qualifier here, is the word potential. It doesn't require the exact resources. It doesn't require the very resources.
But how is the commission supposed to evaluate whether those resources are viable? I mean, you can come in and say, we're going to provide this much solar, we're going to provide this much wind, but the commission doesn't know where any of that is going to come from and whether it's a realistic developer who's going to be able to come in and provide those resources.
Your Honor, the commission deals with this all the time. That is, it's presented with modeling. Even if we had the actual resources, there would have been modeling that was presented to talk about how those resources might perform based on assumptions of fuel costs, based on assumptions of what the load would be. I mean, it's a variety of inputs that, still doesn't provide certainty, even when you have the actual resources at hand. But
Isn't the commission in the best position from an area of expertise to determine what information gives them, or how much information and what type of information provides kind of this proxy resource as opposed to this court?
Well,
And
certainly,
shouldn't we defer to the commission because it's an area of expertise?
in situations where you have a very technical sort of determination, of course, the law is that you defer to the commission. However, what we have here is a couple of things. Again, the grafting on of the identify of the actual resources, which is not in the statute, and plus the undisputed adequacy, if you will, that PNM had met its burden. And PNM presented testimony that these are the potential resources. It provided a large array of potential resources that could be approved. The only other testimony on this point was from staff's witness, Eli LaSalle, who likewise testified that yes, PNM met the threshold. So in this case, what we have is once the case has been tried, and the evidence only got better because what PNM did during the hearing, the RFP had been, the bid response has been back, and PNM presented testimony at the hearing that said, our estimates that we filed have been validated. That, there's plenty of resources out there, the pricing is the same, and all that's been validated. And so you have that overlay as well. Yet the commission ignored all that and said, it's not enough.
So I guess my concern is that this is more comparable to an argument that's asking us to reweigh the evidence presented. And I know you're framing it as the potential new resources and what that means under subsection B, but a lot of the argument really is how they weighed the evidence that was presented. And I'm wondering, I guess similar to the chief's question, I feel like we're being asked to reweigh it or reevaluate the evidence as opposed to interpret the statute, which does require something from PNM.
Your Honor, you're correct, but I must respectfully disagree that we're asking for any reweighing of any evidence. Perhaps if there had been counter evidence presented that said this is not enough or that these resources aren't really available or anything of that nature, we could be talking about reweighing of the evidence. But what we're talking about here is the commission's wholesale disregard of the undisputed evidence in this case. And that's really what the issue is before the court.
But if the commission's conclusion is that upon review of the evidence presented, it's not enough, isn't that within the commission's purview as opposed to this court weighing in and determining what is enough?
Your Honor, I would agree with you if the commission hadn't grafted on to the statute that you must provide the specific resources that the company plans to seek approval for. And again, this is a situation where the company was going to file a new case pursuant to the ETA, presenting the very specific replacement resources. If you look at what the commission did in the San Juan case, it granted abandonment before it ever knew what the replacement resources were going to be. That issue was litigated far beyond
But
when
then they
the
ran
abandonment.
into trouble in San Juan, right? Because the resources were not delivered because there were some issues that arose.
There have been some issues specific to the San Juan replacement resources that the commission approved, but again, that's something that occurred post approval of the resources. But again, abandonment was authorized. It was conditioned upon approval of the resources, but that is exactly, if the commission were going to act consistent with what it did in the San Juan case, it would have granted the abandonment conditionally and then hashed out these issues.
You've run out of time.
Thank you very much, John.
May it please the court? I'm going to start out by identifying 3 pieces of important evidence not identified in the PRC's answer brief that support the PRC's finding that P&M did not meet its burden. And I'm starting out with this because these are very important pieces of evidence that support the PRC's decision, and I don't want to run out of time to tell you this. First, and most significantly, P&M's own witness, Thomas Baker, in his direct testimony, used the word hypothetical 3 times to describe P&M's showing of replacement
They
resources.
came back later with the RFP evidence.
I'm sorry, Your Honor?
Am I incorrect that they came back later with the RFP, with the results of the RFP?
They did not, Your
They
Honor.
did not.
What happened was at the hearing, on the first day of the hearing, on August 31st, 2021, P&M witness Falgren testified that P&M issued the RFP for replacement for Four Corners Resources on June 7th. He said they had received the bids back and were evaluating the bids as they spoke at the time of the hearing. He said that P&M was in the third and final stage of the RFP process, which was modeling to identify the preferred portfolios. And this is at volume 29 of the record proper, beginning at page 8855.
So there was testimony about the RFP and where they were in the processing, but not actual presentation of any of the results of the RFP.
That is correct, Justice Bacon. And then,
Ms. Glick, let me ask you,
Mhm.
what's wrong with handling this case the way Mr. Alvidrez described, with granting the petition for abandonment or the request for abandonment subject to the approval of the resources, which seems to be the big hang-up in this case?
Justice Vargas, the problem with that is the language in the ETA. And that is subsection 62-18-4A of the ETA, which was enacted and effective at the same time as subsection D. And it says, quote, "To obtain a financing order, a qualifying utility shall obtain approval to abandon a qualifying facility pursuant to section 62-9-5. So the ETA did not change the standard for abandonment, and abandonment is required under the ETA before P&M can obtain a financing order.
Right, but as I understood Mr. Alvidrez's answer to one of the questions, he said that in the San Juan abandonment, the abandonment was granted, but it was conditioned upon subsequent approval of the new resources. Why is that inappropriate?
Because in fact, the commission said its approval of abandonment was conditioned on a showing of sufficient and adequate replacement resources. In this case, P&M is seeking approval of abandonment without showing adequate replacement resources. In fact, in that earlier case, the commission divided those two issues into separate case numbers.
Right.
And so they were going on simultaneously.
But I still didn't get an answer to Justice Vargas's question. If they approved it without identifying the specific resources in the San Juan case, why was this case treated differently? Why not do the same thing that says, well, approve the abandonment subject to or conditioned upon identification of replacement resources?
Justice Zamora, the commission, it did have specific identified replacement resources proposed by PNM in the San Juan case. That was going on simultaneously as the abandonment case. And again, in the abandonment order, the commission said the abandonment was being approved subject to approval of the replacement resources.
But why didn't the commission do that here? Say, you presented everything else we need to see regarding abandonment. Once you satisfy the resources issue, you're good to go. That didn't happen here.
Well, I think that's because the ETA section 62-18-4D says that in that case, a utility may defer its application for approval of specific resources to a separate proceeding, provided that the application identifies adequate potential new resources sufficient to provide reasonable and proper service to retail customers.
What was different about this case than the San Juan case and what was presented?
In this case, as I was starting to say, the PNM witness himself said that the replacement portfolio was totally based on hypothetical resources. In the San Juan case, again, there was a separate case. The commission bifurcated the PNM's application. The commission had an application by PNM for approval of specific resources.
So let me see if I can capture this. In San Juan, the application itself was more robust, and therefore the commission bifurcated the two decisions. And here, the application wasn't robust enough to bifurcate?
I think perhaps yes, that there was more evidence in the San Juan case that would support breaking up the application into two separate cases, so that one could focus on abandonment and one could focus on the much more specific information provided by PNM on replacement resources.
So PNM says in its brief that the commission has previously accepted proxy modeling as reliable evidence. Is that true?
It is true, and
So
the reason.
So if that's true, what makes this different?
What makes this different is the facts of this case. And
What about the facts of the case makes it different that proxy modeling is not acceptable here, but it's been acceptable in other cases?
Because number one, PNM had evidence of resources that it was looking at and had narrowed down. It's, again, Mr. Falgren said that during the hearing, that PNM had that information. And second, that in this case, there was evidence of the delays in the approved San Juan resources coming online because of the supply chain crisis. You know, the commission has a duty to keep the lights on. And under these particular facts, it was appropriate for the commission to consider or to require the filing of more specific evidence. And
So is it just the commission's position that the proxy evidence wasn't good enough?
Well, yes, because it was hypothetical. In my answer brief on page 19, I said that the most specificity provided by P&M on replacement resources was the amount of each type of resource that it expected to select. Since I filed that brief, I've discovered P&M didn't even provide that amount of specificity. In his direct testimony, P&M witness Phillips said that even the levels of each type of resource depended upon assumptions. And that's at 1 Record Proper, page 681. And at the hearing, Mr. Falgren said that P&M hadn't selected the exact mix of replacement resources. That's at volume 29, page 8721. So P&M cannot make a credible argument that when its own witness said these were hypothetical resources, they cannot make a credible argument that it satisfied either the fourth Commuters Committee factor, which is to demonstrate adequate and available and adequacy of service, or subsection 62-18-4B, which requires, I would say, essentially the same thing. I can't articulate to you a very good substantive distinction between the two. But that section says that P&M, in order to defer an application for approval of replacement resources, has to identify adequate potential new resources sufficient to provide reasonable and proper service to retail customers.
That now needs to say exact replacement resources.
I'm sorry, could you repeat that?
That now needs to say exact replacement resources, correct? I mean, if we were to affirm PRC in this case, the rule going forward, do you agree? PRC couldn't rely any longer on hypothetical modeling. Because PRC is holding P&M at this point to the exact replacement resources. That's what they're requiring in this case. If we affirm it, that's standard going forward, right?
Justice Thompson, I disagree with that. If you look at, and I think this is the main paragraph P&M relies on in the final order. This is paragraph 21 of the Commission's final order. It doesn't say the exact resources that P&M is proposing. It says the actual resources are already under consideration. So it is not saying that P&M has to present actual resources that it is proposing to be approved.
But Ms. Glick, to Mr. Alvidra's point, P&M did identify potential resources. Did they not?
Justice
And isn't
Field,
that what the statute requires?
Justice Field, I disagree with that. It did.
Listing all these RFP responses is identifying potential replacement sources of electricity.
Justice Vigil, I disagree. For one thing, one of the sources of the modeling that the P&M did were bids received from the RFP to replace the San Juan units. And those had expired by the time of this hearing. they were to expire in 2022. So they would not be potential replacements for Four Corners. Again, I want to stress that P&M had to make a showing for abandonment. This court affirmed the commission's use of the commuters committee factors, and the fourth one is to show available and adequate service. They did not show available service. And then under section 6218.4D, that is essentially the same standard. They did not come close.
I don't either.
Is that?
It's buzzing every time the second goes on.
I think my time is up.
It is.
Okay.
You don't know anything about the noise. Was it you? Mr. Marks.
Good morning, honorable justices. I have some prepared remarks, but I can see the court is interested in the difference between the San Juan case and the instant case, and I litigated the San Juan case for Sierra Club. And the difference was, Ms. Glick has told you several of the differences, but a difference I would point is that by the time of the recommended decision that has been identified as contingently approving abandonment, by the time that RD was issued, the hearing on replacement resources had already occurred. So a final order or an RD had not come out, but the hearing had happened. And what was at issue in that hearing was not whether there were adequate replacement resources that would keep the lights on at a cost that could be bearable. It was finding the best portfolio from a number of suggestions. P&M came in with a plan that had, I think, 60% of it with gas units and 40% renewables and batteries. The environmental parties came in with bigger percentages of renewables. The PRC ultimately selected a portfolio that was 100% carbon free. But by the time these orders were issued, there was enough data that there was no question that there was an adequate replacement portfolio could be selected. And so the contingency was on the selection of specific resources, not on whether there was enough resources, adequate resources. And as it turned out, the portfolio that was selected, which was 100% carbon free, everyone thought that was great at the time. And as the court is already aware, by the time Four Corners was in front of the PRC knew that there were problems, that the new resources were not going to be available because of supply chain issues, delays. And so, as Ms. Glick has explained, the commission's ultimate responsibility, I mean, they're not automatons. They're there to use their specialized knowledge to make fact findings, and they made a fact finding that this is just too risky. We know there are issues. It's too risky to rely on pure hypotheticals that are modeled.
Mr. Marks, can I ask you, how did the commission communicate to P&M that they were going to, because of what was going on at San Juan, they were going to require additional information than they might not otherwise require?
The issue had been raised early on, and as the court points out, the hearing examiner heard a motion about this question. So it was known throughout. It was staff raised an exception, Your Honor. Staff raised an exception to the recommended decision approving abandonment and said, we don't have enough, there's not enough information, it's too risky. And certainly the facts of San Juan were known to everyone. P&M responded to that exception, and the PRC weighed the facts weighed its responsibilities and came down with a decision that supported what staff had been very concerned about. And
What we had, as I understand it, and please correct me if I'm wrong, is that we had a recommendation from the hearing officer saying, I'm not going to dismiss this, there's enough to go forward. Then there's an exception filed by staff, is that right?
yes, Your Honor.
Saying, I don't agree.
Not exactly. I mean, those
Okay.
two things happened, but there's a lot in between. So
Right,
early on in the filing, there was a hearing and a ruling on the papers on a motion to dismiss. The hearing examiner said, we have enough of a case to move forward. No interlocutory appeal was taken. And then after the evidentiary hearing and after the briefing of exceptions, so that there was now an RD
mhm,
supporting abandonment, and after the evidentiary hearing, an RD issues, then exceptions were filed. Staff filed an exception saying that the abandonment should be rejected because these resources are hypothetical, and knowing what we know, it's too risky. We don't know costs, we don't know location.
But isn't that after the record is closed?
But there was enough in the record to support that. The arguments happened after the record was closed, and P&M had an ability to respond to the argument, and the commission made a determination.
But they couldn't put new evidence in the
Right.
record.
That's correct. But there was adequate evidence, as Ms. Glick has pointed you to, where P&M acknowledges that what they had was pure hypotheticals. They took the old bids, which were expired, and then they manufactured new hypothetical resources for the modeling. And the commission also indicated not only they had some concern, but that P&M had the data. And if I'm going to kind of try and get back to my prepared remarks, that this was all, the sequence of events resulted from P&M's haste to get an abandonment to the commission. The other abandonments we've seen typically come in what I call the ordinary course of business. The plant's no longer useful, the utility has a more cost-effective way to provide services, and they come with a proposal.
Can I,
That's not this case.
just before you move on to that, I just want to clarify the timeline. Because a big part of the order is that, hey, P&M had the RFP information. That would have been much more suitable than this hypothetical. Did they P&M have the bid information, if I'm following right, after the hearing officer or the hearing examiner's decision, but before the commission made a decision? When was that information available? We know that it was before the order was issued, but was that information available for P&M to present to the hearing examiner?
It certainly was not in their direct case, Justice Samara, and that was one of the PRC's concerns. I mean, effectively what the PRC did was denied abandonment without prejudice. They said, P&M, just come back, fix these things, and we'll look at it again. Sierra Club does not completely agree with that. We had other grounds that abandonment should have been denied that we never reached. But what the PRC told P&M was, you're weak on some things, and these things are important. You had that data. They didn't have it at the start of the filing. The reason why they didn't have it at the start of the filing is because they rushed in because of the Avangrid merger. The Avangrid merger at 6.19, and you can look at 33 Record Proper 12814 if you want to read the merger clause, required P&M to dispose of Four Corners before the merger, or to come to a contract to dispose of Four Corners, and to file regulatory proceedings as soon as possible. So they consummate the merger in October or November of 2020, and then they immediately come in with this filing for an abandonment that's not going to take place for more than 4.5 years. If this was a normal case, they could have developed their replacement resource portfolios. They had more than enough time to do that, but they came in with what they had on the shelf, they repackaged it, And they came in with a purely hypothetical, case of hypotheticals. PRC
So,
at the
Mr.
end.
Marks, I'm not sure you answered Justice Zamora's question. What were the RFPs that PNM was wading through available while the record was still open in this case? The evidentiary record was still open. See,
Yeah.
there was some testimony to that effect that Ms. Quick read.
They had Chief Justice and Justice Zamora. I'm working from memory here. My memory is that they had the RFP results in. They were working on modeling them through. They had not selected a portfolio. That
But
all
they
had
had them
happened.
in hand. so to
That
speak.
they had actual projects. They knew that by the time of the hearing, but it wasn't in the record because there's a procedure, a regular procedure, and the regular procedure is the utility files its direct case when it makes its application. They did that in January of 2021. If they had waited 4 months to file their application, they would have had it. They chose not to because of the Avignon merger, I think. And
Had it, meaning they would have done their internal process of selecting what RFP seemed appropriate.
yes, and they had, and I want to just jump ahead real fast. And we think that this court should affirm PRC for the reasons we've discussed. I was prepared to talk about the stipulation and the breach and why that's another fact finding. The commission came to the conclusion that that data was necessary to compare and contrast the two scenarios that PNM put forward. PNM only put forward two scenarios, one in which the plant stays running to 2031, and the other was their preferred scenario in which the mine operator, the mine owner, got control of the plant in 2025. Sierra Club had bargained for other modeling in the IRP. The IRP had been filed. They didn't do it in the IRP. They didn't do it in this case. The commission decided that, agreed with Sierra Club that that information would have been useful. And I would maintain that those are the kind of factual findings that are delegated to the commission. Before I run out of time, I do want to say that if we lose today, the result is not and should not be that that this court remands with a direction to the PRC to effectively come up with a decision that approves the abandonment. There were only two exceptions that the commission addressed in its final order. There were 20 other exceptions, 10 of which came from Sierra Club, others from other parties, and they stated other reasons why the abandonment should have been denied, problems with the recommended decision. And if this goes back to the PRC needs to consider those arguments on both sides. Otherwise, we will have been deprived of our due process to make those arguments. So I hope that this court agrees with us and affirms the PRC, but if it does not, please keep in mind that sustaining the PNM on those two issues is not tantamount to saying that they met all the legal standards for abandonment. There are other reasons why they did not. And I just briefly want to talk about policy. In PNM's briefing, they talk about from a policy basis that conveying its interest to the entity owned by the Navajo Nation, but controlled by a non-Navajo management team would yield some public benefits. That's that's kind of nutty to me. The ETA's purpose is to close coal, to transition from coal plants to renewable resources. To that end, Section 62.16.14b forbids utilities from using transactions that move coal plants off of regulated utilities books to an unregulated entity as a means of complying with the portfolio standards. Another section of the ETA, 62.16.4a6, calls for reasonable, consistent progress. The commission didn't include it in its order, but in the discussion that's in the supplemental record proper, you can see they also perceived and agreed with Sierra Club and New Energy Economy that this form of the abandonment was against public policy, and that really needs to be considered. It definitely goes head on into what the legislature wanted with the ETA. And with that, I have a couple of seconds. If there's no further questions, I appreciate the court's attention to these matters and that you've obviously read our briefing very thoroughly.
Hope you don't get beeped. Oh, you did? No? You got one of these.
Your Honor, I do want to address one issue first that Mr. Marks raised, and it's this narrative that a number of the parties have tried to push that this was all motivated, the timing of the filing was motivated by the Avangrid merger. And I would submit that the evidence in the record is to the contrary. In fact, Tom Falgren talked about the agreement with NTEC, which is the Navajo Nation chartered company that was going to buy PNM's interest, indicated that the contract, section 6.2 of the PSA, which is, in this testimony is found in the record proper at 288176, that it was NTEC that wanted PNM to make the filing for approval by March 31 of 2021, which is why PNM filed the case when it did. And I also want to circle back to some of the discussions that the justices were having.
Before you do that, I just need some clarity on this RFP. Because now I'm hearing from PRC that you did not provide the actual RFP data. Page 26 of your brief, PNM's testimony confirmed that the FCPP RFP yielded robust results, quote, in terms of the number of bidders, comma, the amount of megawatts and average pricing. So real quick, can you just clarify for us when that data got into the record?
It got into the record at the hearing. What was happening is while the hearing was pending, PNM had had issued an RFP for specific replacement resources.
Right.
And as described by counsel for the PRC, that was, fairly far along, far enough for PNM to have analyzed, here's the bids that we got, here's the pricing that's coming in, here's the amount of available resources. And PNM witness Phillips confirmed that, what we presented in our application is absolutely consistent with the data that we're getting.
But the
From the
data
actual
wasn't
bids.
admitted, right?
That's
actual data.
that's correct, Your Honor.
Okay.
It was not committed. It was not admitted, nor was the selection process at the time of the hearing complete, so that PNM could have come forward with, here's specific resources. But, I have a couple of
So,
observations.
It was just generic testimony about, we've received these bids and we're wading through them. But we haven't made any determinations yet.
Well, Your Honor, I don't know that I would characterize it as generic testimony. This was testimony based on reviewing.
Well, generic in that it wasn't, on page 3 of the response, we got this information and here's the document, and it's not that they weren't admitted, it's that the RFPs weren't actually presented. Admitted makes it sound like it was excluded by the hearing examiner.
The way you reframed it, yes, I
Okay.
totally
All
agree
right.
with you.
Thank you.
But, the company was able to confirm that what it had presented in its application
So,
was verified.
It seems to me that whatever the reason that this abandonment application was rushed, whatever the reason, because you could have gone through all the RFPs and done all the analysis and so forth, but you chose not to.
Your Honor, I must respectfully disagree. The ETA asked utilities to exit coal as soon as they can. This PNM put together this deal after negotiating since 2018. And if you look at the record proper, there's a timeline of the Four Corners negotiations. It's a 28 RP 08684. So this had been going on quite a long time, since 2018, mid-2018. PNM was trying to find ways to exit from Four Corners. One of the challenges in the San Juan abandonment was, well, there's not enough time. We've got to hurry up and rush through this. PNM filed this case in accord with what NTEC wanted, but also to give the parties plenty of time to do the vetting of the resources. And, as my observation from some of the questioning, I don't think Justice Vargas' question was ever really answered about, well, why couldn't there have been a conditional approval of abandonment subject to PNM coming in 3 months later and litigating over the actual resources? And I think, Justice Vigil, you hit on a very important point with regard to the San Juan case, and that is, and other cases as well. When PNM has filed these abandonment applications, coupled with the specific replacement resources, the first thing that the commission does is bifurcate the case. And so we're going to look at abandonment first. When we're done with abandonment, then we're going to look at
So
replacement
what's the
resources.
relief that PNM wants here? Because that seems different than asking this court to reject the commission's position and improve PNM's position. Because I'm not sure that we're there yet, based on your description of abandonment first and then a robust examination of available resources separately that you would have done if there had been 3 months more time. So I'm not sure I understand what your requested relief is here if we were to agree with a portion of your argument.
What the relief we're requesting is that the commission be required to apply the ETA, and specifically section 6218(4D) as written. And that is, grant abandonment, but with instructions that it does not require the actual resources. That's not what the wording of the statute says. And it's uncontested that PNM presented actual evidence about potential replacement resources.
Is it actual evidence or is it testimony about hypothetical evidence? I
Well-
think that's an important distinction.
Well, it was interesting. Ms. Glick quoted Thomas Bacon, who is a finance witness. He is not either Mr. Falgren or who was the head of generation, or Mr. Phillips, who is the actual resource planning witness for PNM. I mean, they were very, very specific about what they were doing. And I think, as Ms. Glick indicated in her argument, when PNM presents the actual resources, it's based on modeling. And she also admitted this commission frequently looks at modeling as a basis to make, very important decisions.
So, Mr. Alvey, I interrupted my own question, which is, what's the requested relief here? Because you've indicated to the court that the kind of typical process would be a grant abandonment, then have a separate proceeding, really drilling down on the adequacy of the replacement potential resources. But you're asking us to just tell the commission too late, you can't bifurcate and approve the whole thing. That seems to me what you're arguing.
Your Honor, what we're asking for is that you tell the commission they were wrong, that on the facts that was presented, PNM met the standard, and therefore abandonment and a financing order should issue, and that PNM should be allowed.
Wait a minute. But what about the unaddressed outstanding exceptions that Mr. Marks talked about?
And Your Honor, I think that's a good point, and I was going to address that. I hardly disagree that they get a second or third or fourth bite at the apple. It was incumbent upon the commission, again, to make a fulsome ruling as to why it was taking the action it was taking. If, the court adopts a situation where the commission can pick one reason to deny an application, and then when the court says, no, that's wrong, and then remands it back, and they go, okay, well, I have another one, we're going to have to build a revolving door on the front of this courthouse. Because, that is not, I don't believe it's the law, and I don't believe it's an efficient way of dealing with this thing. The commission had its chance, and the other parties had their chance if they disagreed to file separate appeals and say, you should have also ruled that, it's against public policy or what have you. I do want to mention the public policy issue because, again, we have a direct parallel with the San Juan case. And in that case, the commission was very careful because the city of Farmington was working with Enchant Energy to continue to operate that plant. So as that case was presented before the commission, there was the prospect that that plant would continue to run. And that's what was no different than here in terms of policy. My time is up.
Well, I do want to make sure, because I kind of interrupted your answer to the chief's question about what your relief that you were asking for. Did you complete the answer as to what the relief you're asking? And I apologize to the chief that I jumped in, but.
Your Honor, unfortunately, on the first issue, I did. On the second issue, which deals with what happens when we go back and there's the issue of prudence, I didn't get to answer what our request for relief is on that. I'm happy to do that if the court will allow.
That would be opening a whole new level of argument that wasn't raised even in your opening remarks. So I'm going to decline the invitation.
Thank you.
All right, counsel, thank you very much for your briefing and presentations today. And the court this case is now deemed submitted to the court for decision. Thank you very much.
Attend the court, please.